Vega against CM and Associates. This is the wrong calendar. No. Go as fast as I can.
Peter to stop talking.
Okay, you can proceed.
May it please the court, my name is John Komisky. I'm with Forcelli, Deegan, Tirana, and we represent the appellant in this action. I'm here to ask that this court reverse the lower court and find that there's no private right of action under the frequency of payment provisions of labor law section 191(1)A, where there is no claim for unpaid wages. The cases addressing frequency of payment claims have repeatedly held that an employee can only recover for untimely, unpaid wages. In fact, research has not uncovered any case law, appellate case law on point, and in fact, there's only one other case, lower case that has discussed this issue, the Hunter case.
But this is a remedial statute, and wouldn't you agree that employees are harmed when they're not paid on time?
Yes, there's absolutely no doubt that is the case.
I mean, it sounds to me like you're arguing that the employer should get the float, essentially. They get, instead, they get this period of time which not to pay the employees, and thereby get interest on this, the payments they should have made to the employees.
I understand Your Honor's point. However, we submit that would be something that the legislature should do. That's something that really the legislature should be left to do. And in fact,
Didn't they do it?
What about the Gottlieb decision from the Court of Appeals, which says that the remedies in 198 are intended to apply to wage claims based on violations of one or more of the substantive provisions of the labor law? Why wouldn't that give us guidance towards allowing this cause of action based on it being a violation of a wage claim?
I'm sorry, Your Honor, which case was that?
Gottlieb.
Gottlieb,
Court of
okay.
Appeals.
Sure. With regard to Gottlieb, it didn't involve a frequency of payment claim without any underpayment of wages. And that's really the key thing here.
The language it used is that it says 198 should be a remedy for wage claims. It doesn't say for overpayment claims.
Correct, but if you look at 198, it talks about underpayment of wages. And
You know, it says that, but Gottlieb says wage claims.
I understand what Gottlieb says, but Gottlieb, again, with all due respect, is distinguishable because it doesn't involve, or it did not involve an underpayment, nor did it hold that a private right of action exists under 191 where there's not been any underpayment of wages. And
You're saying the only time there should be any cause of action allowed is when it's an underpayment, even if there's a clear violation of the wage laws?
that's correct, Your Honor. And there is...
Why should that be the rule?
Well, also, under Labor Law 218, an employee that is untimely paid can go to the Commissioner of Labor, and the Commissioner of Labor has authority to conduct an investigation, and if it finds that the employer violated this, they can assert penalties.
Why is this sort of a second-class claim? Like for other violations of the wage law that involve underpayment, you can bring a private cause of action. So why should this type of claim be treated differently?
Well, there's really only policy reasons which my adversary has made in his, points to me made in his brief that stand for that proposition. However, again, we respectfully submit that there is no case law, nor has my adversary pointed to any case law that explicitly allows recovery under these circumstances.
No cases either way, though. That's the problem. There's no cases that say it's not allowed. There's no cases that say it allowed. So it's basically an issue we have to determine.
Correct.
Without any authority either way. There's no case that says there is no private cause of action. There's just no cases, period.
Well, there's no cases that are binding on this particular court.
Right,
There is the Judge Leverett's decision from Supreme Court, Queens County, which we obviously agree wholeheartedly with, and the reasoning set forth therein, which he relies on the Hussein case from Judge Corman in the Eastern District, which again, not binding on this court, wasn't binding on Judge Leverett either, but he found that reasoning persuasive, and we respectfully submit that that reasoning is persuasive. That court concluded, again, the Hussein case concluded that failure to comply with the frequency of payment provision under Labor Law 191(1)A does not provide for a right of recovery under Labor Law 198(1)(A) in the absence of unpaid wages. And similarly, there were two other federal cases, again, not binding on this court, not binding on the Hunter court. Those are the Coley case and the RAV Investigative and Security Services cases, which involved, among other things, claims under the FLSA, and noted that New York labor law does not provide for a remedy for untimely paid wages, and because the liquidated damages provision under labor law 198(1)A is geared to afford relief for unpaid wages, not late paid wages. And just one other point I'd like to make, Vega, the respondent herein, lacks standing to seek respective injunctive relief or declaratory relief because she's no longer employed by my client, CM & Associates. And the U.S. Supreme Court has held in the Walmart stores against Duke's case that former employees have no claim for injunctive or declaratory relief relating to an employer's employment practices. And if the court doesn't have any other questions, I reserve my time for a rebuttal. Okay.
Thank you.
Your Honor, may it please the court, Mr. Abdul Hassan, for plaintiff respondent, Ms. Irma Vega. All of the arguments that the defendant makes in this case have been rejected in the context of the FLSA. Now, while the statutes have different names, the arguments and the issue is precisely the same, or very close. The issue in those cases was whether or not a violation of the payment requirement triggers the remedies available in the statute. That's settled black letter law. The ruling on the FLSA side were based on the policy of prompt payment of wages. That rationale is even more compelling on the New York labor law because we, unlike the FLSA, which doesn't have an explicit requirement for payment, frequency of payment, New York by statute, has imposed a requirement that manual workers be paid weekly. And there's a variety of reasons for that, which we also addressed in our brief. There's no dispute here that there was a violation of that requirement. That violation, based on the interpretations, not just by the federal courts of appeal, the New York Court of Appeal in the Brooklyn Savings case, the Supreme Court of the United States, as well as several lower courts, hold that once the violation occurs, it creates a cause of action, and the remedy is available. The payment a week later is merely an affirmative defense that may take care of the underlying wages, but does not take care of the other remedies that the plaintiff seeks, liquidated damages and interest. If you follow the federal decisions on this, they strike a very good balance. They said that the defendant is not without a remedy, that if the defendant can establish a good faith affirmative defense, the judge can eliminate liquidated damages as a remedy and only grant interest.
Counsel, let me ask you about that 1 minute. Labor Law 191A-1 says that liquidated damage shall be calculated by the commissioner, it says, at no more than 100% of the total amount of wages found to be due. Now, the question is, found to be due when? After an adjudication, or when is that found to be due tied to?
There's powerful guidance from the New York Court of Appeals and from the federal courts under the FLSA, which uses similar language. Both Article 6 and the FLSA, by the way, Article 6 existed before the FLSA, and the Supreme Court in Brooklyn Savings actually cited to Article 6 as part of the rationale for its holding.
Give me the temporal answer.
The answer is wages found to be due by the due date set by the statute. And the due date set by the statute is a weekly due date.
Is the weekly payment?
Weekly payments, yeah.
By the, okay. That sounds like a very complex, if you have multiple weeks of late payment, that sounds like an extremely complex
well, it's not
calculation. I'm
uncommon.
not saying that's not a reason not to do it, but.
It's not uncommon in wage cases. Usually when we do these cases, we will create, and I've had cases with the counsel's firm in the past, we will do a spreadsheet for a 6-year period, and you have the records. It can be done actually more easily than damage calculations in other cases. You plug in a formula into a spreadsheet, and within 15 minutes to half an hour, we can kick out the numbers. So the defendant's position will also invite you to create mischief with the settled principles of law, such as when does the cause of action accrue? Does it accrue at the time you file the lawsuit? That doesn't seem to make sense. Or does it accrue when the violation occurs? When does interest accrue? Does it accrue when you file the suit, or does it accrue when the violation occurs? I think Justice Franco below.
Well, those issues, including the issue of how you calculate wages for the purposes of liquidated damages, they're not part of this appeal. The simple issue on this appeal is, does it create a right of action, right?
Yes, Your Honor.
All right, same thing. I just want to be sure. I see your adversary raised the issue about standing for declaratory judgment. I don't see that as an issue that was raised on appeal. It may be true, but we're not called upon to decide that. We have a simple task, as it were, as to whether a late payment, a claim of inappropriate frequency of payment, which actually is a late payment claim, exists even where there are no wages due, right?
No
That's it.
underlying wages, yes. That's correct,
Okay.
Your Honor. And my time is probably up, so I thank you very much, and I urge you to affirm the order and ruling of the lower court.
Okay, thank you.
Okay.
Rebuttal.
Just briefly, if I could get to Your Honor's question, you were just asking my adversary about the declaratory relief. The complaint does seek that, and we did move
No,
to
your
dismiss
brief
that.
doesn't, though. It's not on appeal. I just looked at your brief. It doesn't.
It is raised in my
No,
brief.
Not as a point, not as a question.
It's, the argument is raised in point 2 of my brief, on page,
You're saying on page 18 of your brief where you just raise it at the end.
correct. Yes, Your
They
Honor.
lack standing for that.
Yes, Your Honor. And that issue was fully raised and briefed on the court, in the court below, and the lower court decision did raise that issue. And just one thing, just to kind of bring everything full circle here. It's telling that there's no cases in New York State on this point, appellate level, under New York labor law. The only cases are this particular case and the Hunter case, at least as far as I know, and my adversary hasn't cited any other cases. One critical thing that hasn't been discussed is that 198-1-A provides for recovery of attorney's fees. That's really what's governing, what's ruling this whole case here, is this is really
I know
a
you
grab for
argued that,
attorney's
but
fees.
maybe that's true. But that doesn't stop the fact that where there's a remedial statute that doesn't allow for really big damages, that allowing for somebody to bring a representative action in a remedial way that allows for attorney's fees doesn't serve a purpose. So yes, you might be right, that might be the only element of damages here. I'm not sure, but again,
Right.
we don't need to decide that, right?
I agree, Your Honor, correct. But again, we submit that the Hunter case was correctly reasoned, and that the cases that it relies upon from the federal court are also correct, and that the court should reverse the decision. Thank you.
Thank you. Lists against Sage Systems.